Okay. Hello. So, dito tayo ngayon sa ating last lecture video for this subject. Ano ba itong subject ito? Loan Obligation and Contract. So, pag-uusapan natin ngayon chapter 6, 7, 8, and 9. And yung last part which is the natural obligations. So, dito muna tayo sa first part natin, yung kinds of defective contracts. So itong defective contracts, ilang beses naman natin ito na-mention beforehand pa, di ba? And as I have said, itong defective contracts will be pagdating sa questions about contracts, ito yung magiging parang main focus, kumbaga. Ito yung magiging main focus pag sa board exam. Pag yung topic is contracts, ito yung magiging main focus ng questions. Bakit? Kasi ito yung klase ng ito yung topic under the contract sa kung saan mapapaisip ka talaga, mapapa-analyze ka talaga. Kasi dito nagpo-provide din ng mga remedies and damages. Dito talaga napapaisip yung yung nagtitake ng exam, itong topics na to. So dito, as we have said, 4 ang defective contracts na meron tayo. Una, rescissible. Pangalawa, voidable. Pangatlo, unenforceable. Pang-4 would be the void or inexistent contract. So, nakita niyo naman dito sa natin. Dito sa reference material natin, di ba? Naka-provide naman yung summary for each of the defective contracts, and nabigay naman natin yung G's nila, di ba? Sa mga previous discussion natin, i-insert natin kung ano yung mga basically main principle ng mga defective contracts na to. Di ba? Ang rescissible. Diba? Rescissible contracts valid until they are rescinded. Bakit sa valid? Lahat ng essential requisites present. However, due to some external factors, the law provides that it may be rescinded. It may be cancelled. Yeah? Essential requisites, goods, walang problema. Because, as I've said, because of some external factors, for the protection of the rights of the people, it may be rescinded. Yan si rescissible. Voidable, as we have said, valid until annulled. Di ba? Valid until annulled. Kasi wala naman problema kay voidable contract. Pwede siya Pero there are certain defects, particularly with the consent. Yan yung nagdi-distinguish kay voidable contracts. Yung defect nasa consent. It is valid until annulled. It can be ratified. Pangatlo, yung unenforceable. Itong unenforceable, valid naman siya. Kaso may problema lang, yung sa enforceability niya. Kasi from the name itself, di ba? Unenforceable. However, take note of this. The validity of the unenforceable contract is between the voidable and the void contract. Nasa gitna siya. And speaking of void contracts, ito na yung wala talaga. Snub mo talaga siya. As if it never existed. Ganun yung pagdating sa void inexistent contract. Because of its validity na invalid talaga. Yeah? It is considered to be as if it had never existed. So, yun. So, dito tayo ngayon, chapter 6 tayo, sa rescissible contracts. So, madali lang naman tong topic na to. Wala tong problema. Joke lang. Mapapaisip ka talaga sa topic na to kasi may mga things to consider. Kasi may mga pagdating sa question sa board exam, usually imimix yan guguluhin ka yan. Kung mapapaisip ka, rescissible ba to? Parang unenforceable. Hindi, voidable to. Papaganon ka talaga pagdating sa questions about defective contracts. Yun yung pinofocus niya Gaano mo kakabisado itong defective contracts? Gaano ka ka-sure na ito ay rescissible? Gaano ka ka-sure na ito ay unenforceable, voidable, or void? Don't worry, provided naman yan. Oo. Ang gagawin mo na lang, i-memorize or familiar. Mas preferred i-memorize mo Para yung may particularities talaga So, i-memorize mo kung ano yung mga contracts na kinoconsider as valid, kinoconsider as voidable, kinoconsider as rescissible, unenforceable, void. No? Listed naman yan Wala namang problema. On your part na lang yan para kabisaduhin. Yeah. Kabisaduhin din yung mga remedies nila. Yeah. Ano ang rescission? Anong annulment? Anong ratification? Ratification, pag-usapan natin, di ba? O ratification, yung niratify, inaayos. Ano yung kinoconsider as void? Ilang years bago ka pwede mag-file for this, for that. Yeah? Provided yan. And lumalabas na sa board exam. So dito tayo ngayon sa Chapter 6, Rescissible Contracts. Article 1380. Contracts validly agreed upon may be rescinded in the cases that is established by law. So, as you have said, rescissible contracts, they are validly agreed upon because lahat ng essential requisites nandiyan naman. Therefore, legally effective, but in the case established by law, the remedy for rescission is granted in the interest of equity, fairness, justice. Essential requisites present, walang problema. Kaso, due to some external factors, as you have said, medyo dehado. Medyo dehado yung isang party. Medyo dehado. So with that said, in the interest of equity, fairness, justice, the law has provided na okay. If that's the case, you have now the option to rescind the contract. Walang problema doon. So valid, binding force of rescissible contracts, enforceable, valid, although the subject of the rescission by the court where there is economic damage or prejudice. Ito yung nagiging reason. Ito na yung sinasabi natin external factors which provides for the remedy of rescission. When there is economic damage or prejudice to one of the parties or to a third person. Tawag natin yan lesion, injury, loss, damage. Pero tinatawag natin dito pagdating sa rescissible lesion, L-E-S-I-O-N. Lesion, injury, damage, loss. If that contract has caused lesion to one of the parties or to a third person, yeah? So in the interest of equity, fairness, justice, okay, that injured person, that injured third party, that injured can file an action for rescission in order to protect his rights. Yeah? Ganun yung kasimple. So rescission is a remedy granted by law to contracting parties and sometimes even to third persons in order to secure reparation of damages caused them by a valid contract. So yun yung sasabi natin, valid contract, external factor, has caused lesion, damage, injury, loss to a party. So in order, paulit-ulit tayo dito, repetition is the key. So by means of the restoration of the things to their conditions in which they're prior to the celebration of the said contract. So yan yung restoration, may separate na yan, may separate article naman yan, doon tayo discuss natin. So with that said, there are requisites para maka-file ka ng action for rescission, di ba? Para yung action for rescission, sila. Daming siyon dito. Lesion, action, rescission. So, sana tayo? Anong sabi ko? So, itong action for rescission, may mga requisites para pag mag-file ka, sure bells ka na at least, di ba? Magagrant yung action mo, yung petition mo, kumbaga. So, ito yung mga requisites yan, di ba? So, yung remedy of rescission, ito yung mga requisites niya. Una, the contract must be validly agreed upon. Kasi as we have said, rescissible contracts are valid contracts. Yeah? So, dapat valid muna yan bago maka-file ng rescission, ng action, ng remedy for rescission. Second remedy, there must be a lesion, yeah? Injury, loss, yeah? Damage. There must be a lesion or pecuniary prejudice to one of the parties or kahit sa third persons. Oo, sa third persons na involved sa contract na may interest sa sa contract. Rescission. Pangatlong requisites, kapatid. The rescission must be based upon a case specially provided by law. So, hindi ka lang pwedeng basta mag-file ng rescission. May mga certain cases na doon ka lang. Yun lang yung pwede maging basis. Yun lang yung pwede maging reason, yeah, para mag-file ng rescission. And provided naman kung ano yung mga cases na yun. Ano yung mga instances na pwede ka mag-file ng remedy for rescission. Pangapat, there must be no other legal remedy to obtain reparation for the damage. Ito, take note of this. Matu-true or false question ka dito. Ang action for rescission, ang remedy for rescission, last resort na yan. Last resort na yan. Hindi yan yung first option mo, hindi yan second. Yan yung last option mo. Pag wala ka ng ibang choice, action for rescission na. Bakit? Because the law, the intention of the law is to protect and preserve the contract, not to immediately extinguish it. Yun. ang reason. So, tandaan nyo baka matutrue or false question kayo dito pagdating sa board. Rescission is only a option of the last resort. O, pag wala ka ng choice, action for rescission niya. I-rescind mo na yung contract. Bakit? Kasi ang intention ng law is to protect, is to preserve a contract. Hindi niya intention na at the first place pa lang, extinguish na. No, ang gusto ng law, i-preserve din ang kontrata ng mga tao. So, kaya ang sabi dito, ang rescission, last option na yan. Yeah? Panglima, the party asking for rescission must be able to return what is obliged to restore by reason of the contract. May discussion sa separate article. The object of the contract must not legally be in the possession of third persons who did not act in bad faith. Oo, kasi nga, bakit mo may separate separate article naman yan i-discuss. Pero basically, ang logic yan sa pang-anim na requisite is, bakit mo paparusahan yung taong wala namang ginawang kasalanan, di ba? Kaya, pag good faith, wag mong parusahan. Pero pag bad faith, parusahan mo. And last requisite, the period for filing the action for rescission must not have prescribed. So, ito na yung ito yung sasabi natin na may mga certain instances na kung saan hindi forever na available yung action for rescission mo. And so with other petitions and actions, hindi yan forever na available. May certain prescribed period. Yan yung tatawag natin prescription. Diba? Prescription is basically prescription is basically a manner or a process in which the passage of time will determine if you will gain the right or if you will lose the right. Yan yung basically main gist ng prescription na yung passage ng time will determine if, ulitin lang natin, you will gain a right, or you will lose that right. So in this case, the period for filing the action for rescission, that is your right to file if the law provides it. The action for rescission must not have prescribed. Meaning, hindi yan forever, as we have said, hindi yan forever na available yung option na sa'yo. Pag nag-prescribe na yan, wala ka ng choice. Oo. Wala ka ng choice. Hindi mo na pwedeng ma-file yan. So, may limited number of years lang yan kung kailan ka pwede mag-file. Oo. Yan yung tatawag natin prescription. Ulitin natin. Yung main principle ng prescription is, due to the passage of time, you will, your right, you will gain a right, nakadepende sa passage of time, or you will lose a right. Depende yan sa anong cases provided. In this case, due to the passage of time, you will lose the right to file an action for rescission. Sir, ilang years? Gaano katagal? Depende sa case. Provided naman dito, sabihin natin later on. Pero yan, prescription tawag doon. So, let's go to Article 1381. So, ito na yung mga cases na kung saan, ito na yung mga listed cases. Some of the listed cases na kung saan pwede ka mag-file ng action for rescission. So, Article 1381, the following contracts are rescissible. Ito na. Ito na mga examples. Una, those which are entered into by the guardians whenever the wards from whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. Number 2, those agreed upon in representation of absentees if the latter suffer the lesion stated in the preceding number. Pangatlo, those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due to them. Pangapat, those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. And lastly, all other contracts specially declared by law to be the subject to rescission. So, Articles 1381 to 1382 enumerates the 6 types of rescissible contracts. Ito na yan. Sabi natin kanina, pwede ka mag-file ng rescission on certain cases provided by law. Ito na. Naka-Article 1381 and 1382. Ito lang yung mga certain instances na kung saan pwede ka mag-file ng action for rescission. Ito lang yung mga certain instances na kung saan pwede ka lang mag-file ng action for rescission. So, ito. Ilan to sila? 1, 2. So, contracts entered into in behalf of wards. Ang ward, kapatid, ano yan, no? It is a person under guardianship. Di ba? Kasi may guardian tayo. Ang tawag sa ginaguard niya, di ba? Ginagabayan niya is the ward. So, a ward is a person under guardianship by reason of some incapacity. Whether that's minor, di ba? Kasi as we have said, minor cannot handle their properties until they reach the age of the majority, until they are already emancipated. Another incapacity is yung mga kapatid nating disabled, mentally disabled, no? They are incapacitated to take care of their properties due to their disabilities. Yan, mga certain yan. So, ito yung nasasabi natin, incapacity. So, with that said, kailangan nila ng guardian para i-manage yung kanilang properties, i-manage yung kanilang welfare. So, dito tayo, contracts entered into in behalf of wards by their guardians. So, tawag dito, nabubulol na naman tayo. Those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. Now, take note of this. Ang nakalagay, by more than 1/4. More than 1/4. Hindi less than 1/4. Hindi more than and equal to 1/4. No. More than 1/4. So, kung itong 1/4, pataas. Yung dapat na cause na damages. Na cause na lesion. Ito example. G is the guardian of M. M being a minor. G sells the property of M worth 20,000. Tapos ang binenta na lang for only 15,000. Now, take note of that. 20,000 yung value. 15,000 binenta. 1/4 yung difference. Is there a valid ground for rescinding that contract? No. Because that's only 1/4. It's not more than 1/4. So if it's more than 1/4, then there's a valid ground to file an action for rescission. Oh, may lesion More than 1/4 lesion. So take note of that Be careful of that. More than 1/4. More than 1/4, hindi less than 1/4, hindi more than or equal to 1/4, but rather more than 1/4. Next, contracts agreed upon in representation of absentees. An absentee is a person who disappears from his dos. Ito absentee, mga absent na tao. Pero yung absentee, meron namang official. Yeah? Mayroon siyang official definition sa batas natin. So, ang absent is a person who disappears from his domicile. Domicile being the place of residence, yung kung saan talaga siya nabibilang. And pagdating yung sa law, may ibang, may ibang definition rin yung domicile sa residence Pero yung domicile, kung saan ka talaga nakatira, saan talaga establish. Pero sa mga law peeps na lang yan, ang problema sa definition or sa argument yan. His domicile is whereabouts being unknown. Siya? Disappears from his domicile for which his whereabouts being unknown and without leaving an agent to administer his property. So, basta lang siya nawala, hindi mahagilap, hindi alam kung saan, tapos wala siyang iniwang tagabantay, facilitator, taga-administer ng kanyang property na iwan. So, yun. With that said, yung magkakaroon ng representative niya. So likewise, the absentee must suffer lesion by more than 1/4 of the value of the property object of the contract entitled to entitle him to the remedy of rescission. So yun Same sa sa ward 1/4, more than 1/4. Take note of that. So to take itong spoiler na ba kasi last article to Tapusin ko na itong case rescissible contracts para masabi natin yung prescription nila. Kasi itong case rescissible contracts may kanya-kanyang prescription to sila. Kung ilang years, kung kailan ka, last article lang yun. Last article lang yun, no? Kasi last article siya located Wag tayo spoiler. Charot. Sa last article lang. So later on na yung prescription nila. So contracts undertaken in fraud of creditors. Ito, di ba? Ilang beses ito na pag-usapan, di ba? Na kung saan, di ba? Si D, may utang kay creditor. Kung saan, in order to escape his payment to his creditor, either dinonate or binenta ni D yung kanyang property, for example, yung lupa, kay third person. Either dinonate or binenta. in order to defraud C. Para, di ba? Kasi inisip ni D, hindi ako makakabayad ng utang nito kay C. Sige, para hindi ako makabayad sa kanya, para kunwari, wais ako, makatakas ako sa pagbayad ng payment ko kay C, para hindi niya makuha yung property ko, hindi niya ako makompel, di ba? I-transfer ko na yung property ko dito kay third person, whether that's a relative, para walang mahabol sa akin si C, di ba? Walang mahabol sa kanya si C. So that's defrauding, di ba? The creditor. Ilang beses ito na-discuss last time pa, di ba? Kung mga instances na defraud si creditor. Tapos si creditor, of course, he needs to protect his right. He needs to protect his right. So, anong gagawin ni creditor? Pag nalaman niya, debtor, bakit yan transfer yung property mo dito kay TP? Ha? Hindi ko nga nababayaran yung utang mo sa akin. Naloko ka. So, yun. Target niya to. Action for rescission. In order to protect his interests. Yan ang gagawin ni creditor, diba? Ilang beses natin na-discuss last time. In order to protect his rights, diba? In order that fraud of creditors may be valid ground for rescission, the following requisites must also be present. So in that case, may requisites dito. Diba? There must be an existing credit prior to the contract to be rescinded, although it is not yet due or demandable. So ito yun, may utang si D kay C. May utang si D kay C. Second, there must be fraud on the part of the debtor which may be presumed or proved. Diba? Ito, in this case, debtor transferred his properties whether by donation or whether by gratuitous donation or onerous sale, diba? Kay TP, kay third person, para walang mahabol sa kanya si creditor. Diba? Kala niya wais siya, pero sabi ng batas, no, that's defrauding. Huwag kang ganyan, kapatid. Bayaran mong utang mo. So, yan yun. Second requisite yan. And the creditor cannot recover his credit in any other manner, it not being required that the debtor be insolvent. So, whether insolvent or not si debtor, yeah, pag si creditor, hindi niya wala siyang marirecover kay debtor, na yun na, pwede niya na habulin to. It does not necessarily mean na dapat insolvent. Oo, kasi pwede siya maging solvent, di ba? May mga instances na solvent ka. Hindi yung humihitit, May mga instances na solvent ka. However, yeah, yung solvent ka, ibig sabihin mas mataas yung assets mo compared sa liabilities mo. However, hindi ka liquid. Hindi liquid yung properties mo. Meaning, mahirap silang i-liquidate. Mahirap na i-convert into cash. So, mahirapan kang bayaran yan. So, yan hindi ka liquid, di ba? Hindi madaling i-liquidate properties mo. So, naisip mo, para makatakas sa pambayad kay creditor, transfer mo na lang kay third party, kay TP. Para walang mahabol sa'yo si creditor. Kala mo wais ka, pero sabi ng batas, no, bawal yan. You're defrauding the creditor. So yan, in that case, pag nakompleto mo yung tatlong requisites, tandaan yung requisites na yan para maging valid yung defrauding mo, para valid yung action for rescission mo for defrauding the creditors, di ba? Yan na. Creditor, loko ka debtor Bakit yan? Ayaw mo magbayad ng utang sa akin, sige ka, magpa-file ako ng action for rescission. And pag napatunayan yan na gusto mong i-defraud yung creditor mo, pwede pa yung masama with damages because you have bad faith on your part Pero nakadepende na yun sa korte. So, where the fraud charge is not the one used to obtain sa party's contract, it can only be a fraud of creditors that gives rise to rescission of ending. Pangapat, contracts which refers to things under litigation. Anong meaning under litigation? Nasa korte, pinag-aawayan, o yung property, kung sino totoong may-ari, ganun yan. So in that case, di ba? In that case, this is a piece of land. Si A and si B, pinag-aawayan to. Di ba? Si B, yung current nag-occupy, pero si A, ina-assert niya yung rights niya. Nasa dapat yung may-ari niyan. Di ba? Ganyan nangyari. Then itong si B, habang under litigation tong land na to, binenta. Oo, binenta kay C, yung property. Under litigation, binenta ni B kay C. Di ba? So in that case, anong mangyayari? Di ba? If during the pendency of the case, B sells the land to C without the approval of A or the court, the sale is rescissible the moment na mananalo si A sa kanyang kaso. So, yun yung problema doon. Si B, A, nag-aaway sa lupa. Binenta ni B kay C during the pendency, during the litigation. Yeah? Tapos biglang nanalo si A. Aba, Diyos ko, paano yan? Paano yan? So in that case, if A in case he wins his suit for the recovery of land, yeah? Recovery of said land, pero take note, may caveat yan. May konting minute details yan na pwedeng magkagulo dyan. Paano? If C acquired the land in good faith, yeah? If C acquired the land in good faith, yeah? Hindi niya alam na under litigation to. Oo, hindi niya alam under litigation. Yung tiningnan niyo yung title ng contract, wala naman nakalagay. Hindi naman annotated doon sa titulo ng lupa na may lien or under litigation. So in that case, good faith yung possession. Good faith yung acquiring ni C. So pwede bang mahabol ni ACC? Hindi. Kasi gaya ng sabi natin, huwag mo paparusahan yung taong good faith. Huwag mo paparusahan. Good faith yan eh. Bakit paparusahan yung naging diligent, yung inayos, yung pag-process ng kontrata? Hindi. Huwag mong parusahan. Yung bad faith ang parusahan mo. So, paano yan? Pag alam ni C, na under litigation pala yung contract o yung lupa, subject of litigation, alam niya, pero binili niya pa rin kay B, yun. Pwede siyang mahabol ni A. Kasi bad faith yun eh. Alam mong under litigation yan, bakit mo binili? So, you're entering into a risky transaction. Di ba? So, ganyan. So, good faith, wag parusahan kapatid. Ito, mga additional notes to dito, di ba? Dito. A, however, may protect his property or may protect his right by filing a notice of lease pendens. Di ba? Anong meaning nun, sir? Lease pendens is basically a notification filed kung saan you're basically informing the whole world, parang sa real rights, you're asserting your right over the whole world, over this property, over this real property, di ba? Yung real rights. So parang ganun din yun dito. Pero dito sinasabi mo lang, by filing a notice of lease pendens, you're informing basically the whole world na, oy, take notice mga kapatid, this property is under litigation, di ba? And I'm a party into this litigation. So, warning lang. Huwag niyong basa-basa bilhin to because you're under this. Yeah? You're informing the whole world. This property is under litigation. So in that case, pag ano yung nangyari, anong magiging dynamics ng case na to? Etong si C, kahit na hindi siya personally aware na this property is under litigation, pero si A, in order to protect his right, file a notice of lease pendens. Yeah? Hindi yung magiging valid defense ni na, hindi ko yan alam eh. Hindi eh. Nag-file ng notice of lease pendens eh. So, that's valid na inform yung third persons na this property is under litigation. So, hindi pwede mag-iano si C doon. So, yan mga additional notes lang yung notice of lease pendens, pag real property, pag personal property naman, yung custodia lehis, di ba? So, take note lang yan. Pero pag walang lease pendens, tapos hindi aware si C, with due diligence on his part, okay, good faith yan siya. Valid defense yun. Hindi pwede bawiin sa kanya yung land. So, ano mangyari dun, sir? Payment of damages na lang ang gagawin ni D. Well, hindi mo pwede parusahan si C, good faith. Pero pag may notice of lease pendens, hindi valid defense si C yung kanyang pagiging good faith. Kasi, notice of lease pendens is basically informing the whole world that this property is under litigation, basically putting a warning sign na, uy, if you will buy this property, you're under the risk na makukuha to sa'yo. Okay? And lastly, other instances provided by law. Ito, mga basahin nyo na lang to. Other instances provided by law to. So, 1382 tayo, di ba? Sabi natin, there are 6 rescissible contracts under Article 1381 and 1382. So, yung 1381, 5 sila. Ito naman sa 1382, yung pang-anim. Payments made in state of insolvency for obligations to his fulfillment, the debtor could not be compelled at the time they were effected are also rescissible. So, ito yung another one. Ano meaning ito? Yeah? Nagmo-move yung page. So, payments made in a state of insolvency for obligations to whose fulfillment the debtor could not. Di ba? Basically, ano nangyari dyan? Si nag-move. Si debtor may utang kay creditor. May utang din sa kay kay A, may utang din sa kay B, yeah. Palautang siya may utang din sa kay C. Ngayon, ang problema dito, anong problema dito? Payment made in state of, si debtor insolvent, si D insolvent siya. Ngayon, may mga certain instances na tawag ito, yung utang niya kay C due and demandable. Due and demandable. Utang niya rin kay A due and demandable. Kasi ang ginawa niya, binayaran niya yung utang niya kay BNE kahit hindi pa due and demandable. Yeah? Yung utang niya kay CNA, due and demandable na. Parang example lang yan. Pero yung utang niya kay BNE, hindi pa due. Hindi pa demandable. Or, meron siyang natural obligation na hindi naman enforceable, di ba? Hindi naman siya pwedeng pilitin na gawin. Pero ginawa niya. Now, anong mangyayari in that case? Pwede yung i-rescind. Bakit? Reasoning dyan is, bakit mo gagawin yan? Hindi ka naman required gawin yan. Unahin mo muna yung mga bagay na required mong gawin, na obligado kang gawin. Diba? Common sense. Unahin mo muna yung mga due and demandable kaysa yung mga hindi pa na hindi ka required gawin. Like for example, itong debts nito with BNE or pag may natural obligations din siya. Kasi as we know, natural obligations are not enforceable, di ba? So yung logic ni 1382. Bakit mo gagawin yan? Bakit mo babayaran yan? Yeah? Bakit mo gagawin yan? Bakit may perform obligation mo dyan? Hindi pa naman required hindi pa naman kailangan. Unahin mo muna yung kailangan mo nang gawin. Knowing na, insolvent ka, priority mo muna yung gagawin mo, yung required ka nang gawin. Obligado ka nang ganun lang sa 1382. Yeah? Common sense. Bakit mo gagawin? Yung kailangan muna. Like for example, di ba? Bakit mo unahin yung pagbayad ng mga luho mo? Unahin mo muna bayaran yung mga utang mo. Parang ganun. 1383. The action for rescission is subsidiary. Ito yung sabi natin. The action for rescission is subsidiary. It is not the primary. Yeah, it is not the primary remedy. Subsidiary lang. It cannot be instituted except when the party suffering damages has no other legal means to obtain reparation for the same. Yun yung problema. Yun yung problema. Yeah? Yun yung problema dyan. Hindi principal remedy ang rescission. Nasabi naman natin to kanina Last resort siya. Last option. Kapag wala ka ng ibang choice, okay, action for rescission. Ano ulit yung reasoning? Because the object of the law or the intention of the law is to protect, is to preserve a contract. Not to immediately extinguish it at a moment's notice. To preserve, to protect the contract. Okay? So, yan. For example, di ba? Yung sabi ting kanina, ano ba magandang wording nito? Si guardian nag-administer ng property ni M. Yeah? Minor. Binenta niya kay third person. TP na lang. Yung property, land, ang binenta niya. Problema, value ng land was 200k. Binenta niya for 140,000. Yeah? So, may 60k difference. So, alam natin, may less yun dyan. More than 1/4. So, in this case, si M, upon reaching the age of the majority, emancipated na siya. Anong una niyang pwedeng gawin? I-recover to. Hindi niya pwede sabihin, rescind natin yan. Hindi. I-recover niya muna yung damage. Yeah? 60k yung damage niya I-recover niya muna. So, pag hindi na ma-recover, okay then, rescind na lang yung contract. Ngayon, sir, paano pag si third party good faith? Di, habulin niya si guardian niya. Wala choice damages. Ganyan yan. So, 1384, rescission shall be only to the extent necessary to cover the damage caused. So kasi yan naman punto ng rescission eh. May damage na na-cause, kailangan nating ayusin. May damage na na-cause, kailangan nating ayusin. So the entire contract need not to be set aside by rescission if the damage can be repaired or covered by partial rescission. Tapos sabi natin, wag mo munang i-rescind yung contract. Since yung pinag-usapan naman natin dito is nagkaroon ng lesyon, nagkaroon ng damage, injury, loss, i-recover na lang yung damage. I-recover na lang yung injury, loss, di ba? I-recover na lang kung ano yung lesyon na nakos. Wag mo nang wag agad-agad na i-cancel yung contract. Di ba? Ganon. So yun, kasi yun may punto natin sa rescissible contracts. Valid contract. Essential requisites present. However, due to some external factors, it has caused lesion to one of the parties or to a third person. Yeah? But, since we're talking about the lesion, the damage, the injury, the loss, ayusin mo na yun. I-recover na lang. Huwag na agad-agad i-cancel yung contract. Yeah? Huwag agad-agad i-rescind. Yeah? So, to Guardian M, 200. In this case, the contract need not to be rescinded. Rescission may properly be applied only to one person cover caused by D. But if G or B is willing to pay the difference, rescission is precluded. So, additional, 1385. Rescission creates the obligation to return the things which were the object of the contract, together with their fruits and the price with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. Neither shall rescission take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. In this case, the indemnity or damages may be demanded from the person causing the loss. So, in this case, the indemnity may be demanded from the person causing the loss. So, when the court declares rescission creates obligation of mutual restitution, so ito na, nag-file ka ng action for rescission. So, ang sabi natin kanina, requisites of rescission, sana yun? The party, di ba yung panglimang requisite, the party asking for rescission must be able to return what he is obliged to restore by reason of the contract. Di ba yung rescission ang nangyayari dyan? Kinakancel mo yung contract. So, pag kinakancel mo yung contract, kailangan mo siyempre isauli kung ano yung natanggap mo. Then, yung other party, ibabalik niya kung ano yung nabigay mo. Kasi you're basically canceling the contract. So, dapat ibalik nyo kung ano yung na-receive nyo. Now, yung sabi ni 1385, kapag hindi mo na pwedeng ibalik yan, hindi mo na restore, either na-consume mo, nasira, nawala, aba Diyos ko, bakit ka mag-file na rescission? Kawawa yung kabilang party. Yeah? Alangan ikaw lang yung magbe-benefit. Yeah? Alangan ikaw lang yung magbe-benefit. Siyempre, kailangan mo ibalik. I-restore. Kasi kawawa naman, pa-file ka rescission, tapos hindi mo na pwedeng mabalik yung na-receive mo, tapos yung other party magbibigay sa'yo. Wala siya marireceive. Unfair yun, kapatid. Yeah? So, kailangan, pag magpa-file ka ng rescission, as provided in one of the requisites, you must be able to restore what you have received, yeah, from the other party. So, yun, obligations to third persons to restore. So, saan dito yun? Ito, when rescission not allowed, diba, the remedy of rescission cannot be availed if the party who demands rescission cannot return what he has obliged to restore under the contract. Neither, yung pangalawang neither shall rescission take place if the property is legally in the possession of third person who acted in good faith. So, medyo may, ayusin lang natin tong, sa contract na to. Diba? Gaya na sabi natin, take note of this lang, may idagdag lang tayo, kulang yung nasabi ko kanina. Etong si, TP, or palitan natin yung pangalan niya, para mas klaro, no? Itong si G, binenta kay D. Yeah? Si G, binenta kay D yung land ni M, being the minor. Ito yung guardian. Ito yung guardian, ito yung ward, si G yung guardian, from the name, di ba? So take note, yung land binenta for 200k, 140 yung land na may value na 200k binenta for 140k. So there's a difference of 60,000. So there's definite, valid ground for rescission yan. Pwede ba tong mabawi? Pwede ba tong mabawi ni M? Oo. Pwede itong mabawi tong land na to. Pwede mabawi, walang problema. File siya ng action for rescission upon him reaching the age of the majority kung saan emancipated na siya. But take note, para mabawi niya yung land niya, kailangan niya munang ibalik yung 140,000 pesos na na-receive niya plus the interest, plus the legal interest. Kasi of course, napag-usapan tayo anong reason yan last time, di ba? Time value of money. So yan na. Paano pag hindi niya na ma-return yung 140k with legal interest? Di wala siyang karapatan para ibalik tong land, para makuha tong land while filing action for rescission, di ba? Kasi kawawa naman si D. Babalik niya yung land tapos hindi niya ma-receive yung binayad niyang pera. Kalokohan yun. Ngayon, ganyan yung istoryahin natin, di ba? Ganyan yung istoryahin. Ngayon, itong si D binenta yung land to a third party. Good faith, innocent third party. Good faith, innocent third party. Binenta niya yung land. Binenta niya yung land. So si M, nag-reach yung age of majority. So gusto niya ngayon i-rescind yung contract, gusto niya bawiin yung land. So habulin niya si third party. Pwede ba? Hindi. Good faith kapatid, good faith. Hindi mo pwedeng parusahan yung taong good faith. Yun yung kulang sa nasabi kong example kanina. Dapat mabenta sa third party para ma-consider as good faith. In this case. So, paano yan, sir? Ano na mangyayari? Kasi GFTP, an innocent purchaser in good faith who takes legal possession, rescission cannot take place. Kasi good faith yan Hindi mo pwedeng bawiin. Good faith yan. Wag mong parusahan. So in that case, the remedy of M is to file an action for damages against his G. Ito na, dito na siya mag-file ng action for damages against G. Kasi sabi, oy, loko ka G. Chicken ka, tingnan mo tuloy. Nasayang tuloy yung land ko. In remorse si M kay G. Kasi because of the act of G, nag-cost ng damages in the amount of 60k sa kanya. Tapos napunta sa third party, inosente, niya pwedeng habulin yan. So yan, si G na lang yung pwede niya habulin. In the amount of 60,000 plus legal interest yan. And to be honest, itong rescissible contracts, ito sa mga this is one of the easy topics under defective contracts. Kaya mas mahirap yung other three. Mahirap pa sila. Pero generally, hindi naman mahirap. Hindi naman sila makahilo. Basta kabisaduhin mo lang ano yung mga instances na this is a rescissible, that will say that this is a rescissible contract, this is unenforceable, this is voidable, this is void. And don't worry, because provided naman yan kung ano yung mga instances na anong klaseng defective contract siya. Kabisaduhin nyo na lang. Ito, 1386, rescission referred in numbers 1 and 2 of Article 1381 shall not take place with respect to contracts approved by court. So ito yun. Ano yung 1 and 2? Yung contracts entered into in behalf of parties and contracts entered into or agreed upon in representation of absentee. So, in cases na kung saan yung kontrata na yun was approved by the court, okay, walang rescission. Approved ng court Kasi in the eyes of the court, inisip niya, uy, valid naman to. This is for the protection of the ward. This is for the protection of the absentee. In the determination of the court yun. So, hindi na pwedeng ma-rescind yun. Saan tayo? 1387. All contracts by virtue of which the debtor alienates the property by gratuitous title, ito na, are presumed to have been entered into in fraud of creditors when the donor did not reserve sufficient property did not reserve sufficient property. Saan dito yun? did not reserve sufficient property to pay all debts contracted before the donation. So, alienation by onerous title are presumed or are also presumed fraudulent when made by persons against whom some judgment has been rendered in any instances or some writ. Lalamig man ako. The decision of the nabubulol tayo. Ulitin ko. Alienation by onerous title are also presumed fraudulent when made by persons against whom some judgment has been rendered in any instances or some writ of attachment has been issued. The decision or attachments need not refer to the property alienated and need not have been obtained by a party seeking the rescission. In addition to these presumptions, the design to defraud creditors may be proved in any other manner recognized by law. So basically, itong 1387, pagkabahaba, pagkalito-lito, it's all about presumption. Presumption of defrauding. So itong sa first paragraph, basic alienation of title, alienation of property. Alienation of property. Yeah? Sana yun? Either by gratuitous title or depende. Kung gratuitous or onerous, depende sa tag ito? Sa transaction. Pag gratuitous title, yun. Donation yun. Mga donation yan. So, di ba magandang example dito? Anong magandang letter? Si B. Nag-donate ng land. Donate siya ng land. Donate. Nag-donate siya ng land kay A. Baka siguro crush niya. Hindi natin alam. So, B made a donation of parcel of land to A. Pero, take note, before the date of the donation, si B, mayroon siyang several debts. Diba? Kay C, D, E, and F. With the donation to A, diba? The remaining properties of B is not sufficient to pay all his debts. Alba, yun na tayo nagkakaproblema. Alam mo na ngang may utang ka. Bakit ka nag-donate pa? Ba't ka nag-donate pa? Alam mo na nga may utang pa. May utang ka, di ba? Tapos dahil sa pag-donate pa na yan, yung properties mo naging insufficient to cover those debts, di ba? So in that case, there's a presumption na, you did that. B did that in order to defraud his creditor C, D, and F. Yeah? Bakit ka magdo-donate? Kulang na nga ang properties mo eh. Di ba? Kulang na nga ang properties mo. Dahil sa pag-donate mo. So in that case, there's a presumption na nag-defraud ka. So with that case, pag-file na sa third instance na yan, yung contracts undertaken in fraud of creditors, like in this for example, file an action for rescission. Ito mga creditors mo, file an action to rescind this donation, in order to protect their rights. So yan, pag gratuitous title, donation. Kasi inisip mo dyan, walang hinihinging kapalit. Wala kang na-receive na kapalit, nag-donate ka lang. Di ba? So next is yung alienation by onerous title. Ito na yung onerous title, di ba? As you have said, yung onerous title is basically, you receive something of equal value by giving something of equal value. Example, sale. Yeah? So, yung provided yan is yung second paragraph. Yeah? Alienation by onerous title are also presumed fraudulent. But take note, yung sale, pag blank sale lang, pure sale lang, walang ibang chuchu bells dyan, huwag ka mag-presume na defrauding of creditors yan. Huwag mo i-presume. Ang mangyayari lang, magpe-presume ka lang na fraudulent siya when made by persons against whom some judgment has been rendered in any instances or some breach of attachments has been issued. So, yun At the first glance, kung walang ibang chuchu dyan, onerous title, ang alienation, like sale, huwag ka mag-presume. Pero kapag merong, provided ng second paragraph, whom judgment has been rendered in any instances or some writ of attachment has been issued, the decision or attachments need not refer to the property alienated and not have been obtained by the parties seeking in decision. In addition to these presumptions, the design to defraud creditors may be proven and other provided by law. So, di ba? Suppose, basahin nyo lang to. Yeah? Pagdating sa gratuitous title, alienation of gratuitous title, by gratuitous title, okay, presume ka agad na may defrauding na nangyari. Yeah? Pero kapag alienation by onerous title, wag mo na mag-presume. Yeah? Wag mo na mag-presume. Magpe-presume ka lang kapag some judgments has been rendered into. Doon lang. Okay? Mga additional notes lang yan. Circumstances denominated as badges of fraud. Ito yung mga The following are some of the circumstances attending sales which have been denominated by the courts as badges of fraud. Ito yung mga instances na masasabi mong may fraud. May presumption, ma-assume may fraud. So, basahin nyo lang yan. Ito, 1388, whoever acquires in bad faith the things alienated in fraud of creditor shall indemnify the latter for damages suffered by them on account of the alienation whenever due to any cause. It should be impossible for him to return them. If there are two or more alienations, the first acquirer shall be liable first and so on successively. So ito na, di na pag-usapan din kanina. Good faith, good faith, good faith, wag mong parusahan. Good faith yan eh. Pero pag bad faith, ayun na. Yeah? Pag bad faith, parusahan na yan. Yeah? May penalty na yan. Hindi na magiging mabait sa iyo yung batas natin. Yeah? The purchaser in bad faith who acquired the object of the contract alienated in fraud of creditors must return the same if the sale is rescinded. Diba? If the sale is rescinded. And should it be impossible for him to return, ibig sabihin niya, due to some reasons, hindi niya pwedeng ma-return, di ba? Either nawala, nasira. So, due to any causes, he must indemnify the former for damages caused. In this case, di ba? Since bad faith ka, no choice ka. Paparusahan ka ng batas natin. Ngayon, should there be two or more alienations, the first acquirer shall be liable first and so on. Like for example, same dito sa natin, yeah? Same natin dito. Si G. Move natin konti. Si G. Minor or guardian ni M. Binenta yung lupa kay C. Land. Yeah? Binenta yung lupa. Awag na ng lupa, mas madali, yung bagay na mas madaling mawala. Kotse. Car. Binenta yung car kay C. Value ng kotse, 500k. Binenta ko lang for 300k. Binenta for 300k. So may lesson dyan, 200k in difference. More than 140. So ano mangyayari? Si M, reaching the age of the majority, emancipated na, proceeds to rescind the contract. Proceeds to rescind the contract. Tag dito. Ay parang pangit na na example, ya. Yung mas madali na lang. Tanggalin natin to si minor. Tanggalin natin si minor. So, ano ba maganda example? Benta-benta na lang. Ayun, maganda example. Defrauding of creditors kasi may bad faith dyan eh. Oo. So, si D, si D may utang kay C. Na may utang. Tapos itong si D, hindi makabayad. Hindi makabayad. Ayaw magbayad kay C. Same reasoning sinasabi natin last time pa. Since ever. So, in order to that, binenta niya yung kanyang property. Nagbinenta niya yung kanyang property. Let's say land. Kay S. Binenta niya kay S. Binenta niya kay S. Ngayon, sabi dito, if the sale is rescinded, nalaman ni C. So, hinabol niya yan. Action for rescission. Now, if the sale is rescinded, CS must return the car. Now, should the car be destroyed or without his fault, then C is entitled to be rescinded. Paano yun? Joke. Kulang pati sa reasoning. Medyo nilalamig ako eh. Lagi bang ihip ng hangin? So, etong si S, alam niya na etong ginagawa ni D is in order to rescind C. Yan yung purpose niya eh. Gusto niyang i-rescind. Gusto niyang i-defraud si C. Alam, aware si S. So in that case, yung awareness niya sa pinagagawa ni D, or baka kutsaba pa siya ni D eh. In connivance, di ba? Nagkutsabahan sila. So bad faith siya. So in that case, bad faith siya. So in that case, kapag nawala niya yung land, nasira niya, di ba? Nag-lessen yung value of the property, or baka na landslide, di ba? Nasira due to any causes, di ba? So kahit fortuitous event yan, di ba? As we have said, basta bad faith ka, kahit na fortuitous event yan, wala kang takas. Kasi bad faith ka. So yan, nasira yung land. So hindi niya na pwedeng masauli yung land kay C. So ano na yung mangyayari? Hindi yan, makakancel. Yeah? Hindi yan masauli yung land kay C. Magbabayad na siya ng damages. Yeah? Magbabayad na siya ng damages. Kasi loko-loko siya eh. Alam niya na nga may problema. Alam niya na nga bad faith siya eh. So, pinaparusahan na ng batas natin yung bad faith. Medyo wala ako sa dito. Suppose B transfer the car to D who also acted. Ito naman. Si S, transfer yung kotse kay B. Kung saan si B, bad faith na naman. Yeah, bad faith si B. So, pag habulin ni CCS for damages, tapos si S hindi makabayad, then next stop niya si B. Sunod-sunod yan. If there are 2 or more alienations, madali na naman to eh. So, yan lang. Tapusin lang natin to si Rescissible. Medyo nawala ako sa mood. Malamig. So, 1389. The action to claim for rescission must be commenced within... Ito na yung prescription. The action to claim rescission must be commenced within 4 years. For persons under guardianship and for absentees, the period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known. Si absent yun. As a general rule, the action to claim for rescission must be commenced. Ito na yung prescription. Within 4 years from the date of the contract was entered into. So, pag yung contract was entered into on January 1, 2020, so, meron ka lang 4 years. So, until January 1, 2024, to file an action for rescission. Pag lumampas ka dyan, di ba? Prescription, nag-prescribe na yung action mo. As we have said sa prescription, due to the passage of time, di ba? You will either gain a right or on the other hand, you will lose the right. So in this case, after 4 years, di ka pa rin nag-file ng action for rescission from the date of the contract, then you will lose the right to file that action. Hindi na pwede. It has already prescribed. May time limit lang binigay yung batas sa iyo. Bakit sir? Anong reasoning behind that? Basically kasi, alam mo na ngang may ganyang nangyayari. Bakit hindi ka pa nag-file ora-orada? Yeah? Ba't hindi ka pa nag-file ora-orada? Hassle ka peeps. By not filing that, by not exercising your right, you waive it. Yeah? Ni-waive mo na. Parang hinayaan mo. Parang implied ratification yan on your part. Implied agreement on your part by not filing an action. Kahit nakarapatan mo yan. So, in order to sabi ng batas natin, para less hassle, di ba? Ilang years, many years na, ngayon ka pala mag-file ng action for rescission? Hindi naman pwede yun. Yeah? Hindi naman pwede yun. May time limit lang. Ngayon, the exceptions are for persons under guardianship, di ba? Yung mga ward. Siyempre, incapacitated pa sila eh. Ward pa lang sila eh. So, kailan sila pwede mag-file? It shall begin from the termination of incapacity. So, pag they already reached the age of the majority, they are already emancipated, doon lang mag-start yung counting ng 4 years. Tandaan yan, ha? Doon lang mag-start yung counting of 4 years. Doon lang mag-start. For absentees naman, yung mga hindi alam kung saan yung domicile nila, then walang iniwang representative for their properties to administer. For absentees, from the time the domicile is known. So, pag nalaman na, na-inform na siya doon Start na ng counting in 4 years. Now, who are the persons entitled to bring action? The action for rescission may be brought by the injured party or the defrauded creditor, his heirs, assigns, succession interest, or the creditors of the above entitled to subrogation. So, yan lang yung ending ng discussion natin, sir. Meron pa. Dito kasi, di ba nasabi ko kanina, na for each instances of the, of situations na rescissible contracts, may certain, prescribed period. So, itong si Ward, itong si absentee, 4 years, di ba? Ngayon, ito nasulat ko dito, sabi nung teacher namin dati, yung 3, 4, and 5, yung contracts undertaken in fraud of creditors, yeah, contracts which refers to things under litigation, and yung other instances, ang sabi dito, periods of within 10 years upon the execution of the contract. Yan lang yung time limit mo. Lawyer nagsabi sa amin yan. So, yan, di ba? So, yung 1 and 2, contracts entered into in behalf of wards, di ba? Contracts agreed upon the representation of absentees, 4 years sila. Yung contracts undertaken in fraud of creditors, di ba? Yung 3, 4, and 5, contracts which pursue things under litigation, and other instances, 10 years, periods of 10 years, period of within 10 years upon the execution of the contract. Yan lang yung prescriptive period mo to file an action. More than that, wala na. Yun yung nakalagay dito sa book namin. Yeah. So with that, yan lang yung discussion natin for rescissible contracts. Take note, rescissible contracts, valid contracts. Walang problema. All essential requisites are present eh. But, ulitin natin, repetition is the key. Due to some external factors, yeah, particularly nag-cause ng lesyon, ng injury, damage, loss sa isang party or sa third party, diba? In the interest of equity, fairness, and justice, you need to rescind the contract. You need to rescind the contract. Valid siya, walang problema. Pero, yun, may rescission na nangyayari. So, yan yung rescissible contracts. So, madali lang, di ba? Now, let's go to chapter 7. Okay. Dito tayo ngayon sa next part ng discussion natin, which is Voidable Contracts, chapter 7, the second form or second kind of defective contracts. So, medyo inahan ko lang boses kapatid kasi around 12:15 a.m. na. So, tulog na mga tao. So, dito tayo ngayon sa Article 1390. So, voidable contracts. The following contracts are voidable or annulable, even though there may have been no damage to the contracting parties. So, yun, di ba? Sa rescissible, kailangan may damage. Dito sa, kailangan may lesyon, di ba? Dito sa, kahit walang damage na na-cause, kahit walang lesyon, goods lang, you can still annul the contract. It can still be considered as voidable. Kasi iba yung basis dito eh. So let's read. Even though there may have been no damage to the contracting parties. Una, those where one of the parties is incapable of giving consent to a contract. And second, those where the consent is vitiated by mistake, violence, fraud, intimidation, undue influence, or fraud. Yung VIMFU natin. These contracts are binding unless they are annulled by proper action in court. They are susceptible of ratification. Diba? Sa intro natin kanina, as you have said, pagdating sa voidable contracts, valid siya, diba? Valid until annulled. Ang nagpapa-defective sa kanya, ang nagiging cause ng defect niya, is about the consent in regards to the contract. Consent yung punto niya, diba? Recap. Sa rescission, ano yung problema? Walang defect. Walang problema, walang defect. Sa rescission, di ba? Valid lahat. Problema lang, external factors. Nag-cause ng lesyon, damage. Pagdating sa voidable contract, anong defect? Nasa consent. Valid siya until annulled. Anong defect? Nasa consent. So, voidable or annulable contracts are those which possess all the essential requisites of a valid contract but one of the parties, kaya nasabi natin, is incapable of giving consent or consent is vitiated by VIMFU. Yung natin, di ba? Mistake, violence, undue influence, intimidation, and fraud. Or yung VIMFU. So, VIMFU. Tandaan nyo yan. Mga mnemonics yan. So, take note, binding force ng voidable contracts, valid and binding between the parties unless annulled by a proper action in court. Now, take note of this. Once na na-ratify yan, hindi mo na pwedeng i-annul. Hindi na pwedeng i-annul. Once na-ratify yan, hindi na pwedeng i-annul yung contract na yan. Valid na yan. Absolute valid yan. Now, as we have said, damage is not necessary for this It's not a necessary requisites. It's not a necessary requisites para ma-consider voidable. Ini-ignore yan whether there's damage or not. So, there are two kinds of voidable contracts. Diba? Parang binabasa natin to kasi understandable naman. A contract is voidable if the defect is caused by, provided naman, legal incapacity to give consent. Diba? For example, minors. Diba? Yung mga mental disabled peeps natin. So, they don't have the capacity to give consent because they are incapacitated. Mga deaf mute natin, di ba? But take note, yung mga drunk, mga under hypnosis, yun, incapacitated sila to give consent. Napag-usapan natin yan, di ba? Sa VIMFU vitiation of consent natin, napag-usapan natin yan. So, pag mentally disabled, nagkaroon ng lucid interval, yun, valid. Yeah, mga ganang style. So, and yung second, is violation of consent. Diba? Na-vitiate yung consent. Yung VIMFU. So, dalawa yan. Yung legal incapacity and yung vitiation of VIMFU. Vices of consent. So, pinag-usapan natin dito yung annulment. So, itong annulment. Ano tong annulment? Basahin natin. Annulment is a remedy provided by law for reason of public interest for the declaration of the inefficacy. Talks about the effectivity, inefficacy of the contract based on a defect or vice in the consent of one of the contracting parties in order to restore them to their original position in which they were before the contract was executed. So, napag-usapan natin last chapter yung rescission, which also cancels the contract, di ba? It cancels the contract. It rescinds the contract, sir. So, anong difference niya sa annulment, sir? Medyo naguguluhan kami. So, basic lang yan. Tingnan nyo yung rescission. Ang rescission, nire-rescind yung contract. Obviously, sir, alangan. Nire-rescind yung contract. Kina-cancel niya. Tine-terminate niya. So, anong sinasabi nun? Valid yung contract Walang problema. Kaso, kinancel nyo lang. Tinerminate nyo lang. And, there should be a lesion on that. There should be damage. Required yun. Pagdating dito sa annulment, anong nangyayari? Dito sa annulment, ang ginagawa nyo, yung contract na valid, ngayon, dinideclare nyo na siya as null and void. Yun yung nangyayari. Sa annulment, yung contract na valid at the first place, ginagawa mo dinideclare nyo ng null and void. Null and void. Yun yung difference niya sa rescission. Plus, hindi kailangan ng requisites for damages for annulment. Sa rescission, kailangan yun. Yung lesion, kailangan yun. So, yun, di ba? Sa rescission. Ulit natin, sa rescission. Diba? Sa rescission. Matawag dito. Diba, sa rescission, kina-cancel mo lang. Tine-terminate mo yung otherwise a valid contract. Diba? Terminate, cancel. Pagdating sa annulment, iba ang ginagawa mo. Dinideclare mo na siya as null and void. Null and void. Iba yung nagiging effect nila Sa rescission, until the end, valid pa rin siya. Kina-cancel mo lang. Sa annulment, valid siya, naging null and void in the end. Yeah? Iba yung pinupunto ng annulment and ng rescission. And yung annulment, consent yung pinoproblema natin dito. Consent. Kaya nga tawag dito, voidable or annullable contract. We're talking about the consent. Rescission talks about the lesion, talks about the damage, injury, loss. So, iba yun. Kaya, may separate sila separate distinction kasi iba yung pinupunto nilang dalawa para hindi tayo magkagulo. Yeah? Para properly proper yung definition. Yeah? Gets na? Okay, ulitin natin. Para repetition is the key. Para rescission, anong focus niya? Lesion, damages, injury, loss. Kung saan, an valid contract is terminated, is cancelled. Pero in the end, valid pa rin siya, di ba? Nati-terminate lang. Naka-cancel lang. Sa annulment, ano nangyari? A valid contract, boom, at the end, naging null and void na siya. Yeah? Valid siya at the first place. At the end, null and void siya. And hindi mo kailangan ng damages cost dyan. Sa rescission, kailangan mo ng lesson dyan. Damage cost, injury, loss. Pagdating sa annulment, no. Hindi essential yung existence of damage, no. Because pagdating sa annulment, we're talking about defect on the consent. Whether that's legal incapacity or whether that's vices of consent, yung VIMFO natin. Yeah? Kaya may separate distinction sila. Kasi ulitin lang natin, iba yung pinupunto nilang dalawa. Hindi same. Not the same matter. Kaya nga may kinds of kaya nga may different defectives contract tayo kasi iba-ibang sitwasyon yan eh. Yeah? Tinatry ni cover ng batas. So to, 3921 tayo. The action for annulment shall be brought within 4 years. Ito, may prescription. Yeah? May prescription. Within 4 years ka lang pwede mag-file ng action for annulment. Pag lumampas ka dyan, you already prescribed. Nawala na yung karapatan mong mag-file ng action for annulment. Yeah? Prescription yan, kapatid. So, kailan tayo mag-start magbilang ng period? Provided naman yung batas yan eh. This period shall begin, diba? In case of intimidation, violence, or undue influence, yeah? Yung sa VIMFO natin. Pero in this case, in particular lang sa intimidation, violence, or undue influence, from the time the defect of the consent ceases to exist. Yeah? Ceases. So, ibig sabihin, yung intimidation, kung kailan nag-stop yung pag-intimidate sa'yo, o yung violence, kailan nag-stop yung pagiging violent sa'yo, o yung kailan nag-stop yung pagiging undue influence sa'yo, doon lang mag-start yung counting. Bakit? Kasi during the existence, o during the performance of the intimidation, violence, or undue influence, diba? Your consent is still being vitiated, continuous yan, habang piniperform yung intimidation, violence, or undue influence. Diba? Continuous yan. So, the moment that such act stop, di ba? Wala nang nag-stop ng intimidation, nag-stop na yung violence, nag-stop na yung undue influence, doon na mag-start yung counting. Kasi from that time, di ba? From that moment, pwede ka na diretso ka na sa korte kasi hindi ka na hindi ka na hindi ka na in-intimidate, hindi ka na bina-violence, hindi ka na ina-undue influence. So from that moment, okay, punta ka na sa korte, start na ng count mo ng 4 years. In case of mistake or fraud, from the time of the discovery of the same. Yeah? From the time of the dito naman, obviously, kasi bakit? Yung dalawang parties, di ba? May at least 2 parties tayo dito, yung good party or innocent party and yung guilty party. Ngayon, etong sa mistake or sa fraud, meron yung mistake, di ba, yung both parties, hindi alam nila. Pero, pag innocent parties, goods lang yan. Pero, ito sinasabi natin, pagdating to sa mistake or fraud, the moment na na-discover mo, yeah? The moment, lalo na especially sa fraud, the moment na na-discover mo yung mistake, the moment na na-discover mo yung fraud, tsaka lang magka-counting. Bakit ka? Kasi kawawa naman. Kung gawin mong starting ng counting yung period of the execution of the contract, tapos yung innocent party hindi aware na may fraud, aba, it is to the benefit of the guilty party yan. Yeah? Kawawa naman yung innocent party, bigla nag-start yung counting, hindi naman siya aware. May fraud pa lang nangyayari. Di ba? Kawawa naman siya. So yun, in that case, the moment that the fraud was discovered, doon lang mag-start yung counting. Kasi aware na si innocent party. Kasi chicken, pino-fraud pala ako ng kung counterparty ko na to. Sige, doon. File ng action for annulment. Pagdating naman sa mistake, yeah? For example, dalawa silang both parties mistake, innocent party sila dalawa. So yun, hindi nila alam, may mistake pala. So upon discovery, nag-usap sila doon. Walang problema dyan. Yeah? Kasi yan eh. The innocent party is unaware of the reason which renders the contract voidable and cannot also be expected to bring an action in court. Kasi hindi naman siya aware at the first place. Di ba? Pag concealed pa yan. So the moment na aware na siya, yun, alam niya nang gagawin. Punta sa korte. Pag unfavorable sa kanya, annulment. Pero pag goods naman sa kanya, edi ratification. May ratification. Which will, basahin natin last paragraph pala ng 1391. And when the action refers to contracts entered into minors or other incapacitated persons, from the time the guardianship ceases. Yun. Diba kasi dalawa types ng voidable contracts, yung sa legal incapacity, yung una, and yung second is yung sa VIMFO, vitiate vices of consent. Pagdating sa legal incapacity, pag minors, upon reaching the age of the majority, emancipated na siya, doon na mag-start yung counting. And sa ano naman, yung sa isa, tawag dito, o yung sa guardianship or when the guardianship ceases, minor sa other incapacity persons, yung mentally disabled, naging mentally abled na. So yun, stop na yung guardianship doon. So doon lang mag-start yung counting ng period. Bakit, sir? Kasi an incapacitated person has no capacity to sue. Because incapacitated nga sila eh. Oo, they're not in the proper position to sue. So yung guardianship nila yun. Pero the moment that the guardianship ceases, okay, start na ng counting to give them ample time, 'di ba? 4 years to file the proper action kung gusto nilang i-annul yung contract. Kung gusto nilang i-annul yung contract. Pero pag goods naman sa kanila yun, proceed sa 3092. Pag okay lang sa innocent party, goods lang sa kanila, walang problema. Proceed to 3092. Ratification. Ratification. Sabi ni 3092, ratification extinguishes the action to annul avoidable contract. Nira-ratify mo yung contract. Bakit? Anong meaning ng ratification? Ito, na-mention natin ito last time pa. Pero ito, mention lang natin ulit ngayon. Ratification means that one voluntarily adapts to some voluntarily adopts some defective or unauthorized act or contract which, without his subsequent approval or consent, would not be binding upon him. So, meaning yan, nag-agree ka kahit na there's a defect or there's an unauthorized act, nag-agree ka, ni-ratify mo, in-approve mo, di ba? Parang it is a subsequent approval on your part. Parang it is subsequently giving your consent, di ba? Ito yung starting, di ba? Diba? Ito yung ano ng contract. Yeah? Ito yung starting. Tapos, nalaman mo dito na may problema. Pero, ni-ratify mo pa rin. Parang subsequent siya. Parang subsequent giving of your consent. Diba? Subsequent giving of your consent. Subsequent authorization on your part. Yan yung ratification. Na, dito, may na-discover ka, yeah? Na pwede may discover ka, di ba? Pero, for you, okay, goods lang. Walang problema yun. Ratification. In-approve mo subsequently. Sa decision, di ba, may ratification din tayo dyan. Na pag yung innocent party, yung na-cause ng damage, kahit na nalaman niya ng may damage, pero goods pa rin sa kanya, okay, walang problema yun. Kasi, discretion niya yun kung itutuloy niya o hindi. Discretion niya yun kung magpa-file siya ng damages, discretion niya yun, choice niya, it is his right, yeah? Kung exercise niya. Same dito sa voidable contract. Kung upon the discovery, yeah, or upon the legal incapacity yan, vitiation of consent, anong gagawin niya after? Annulment? Or ratify niya lang? Kung ayaw niya, sa contract na yun, di annulment. Walang problema. File an action for that in court. Second, kung gusto niya lang, goods na, ayaw. Kasi naisip niya, favorable sa kanya eh. Naisip niya yun. So in that case, okay, ratification. Now, ratification cleanses the contract from all of its defect from the moment it was constituted. No? So nagkakaroon ng retroactive effect. So kung dito na ratify yung contract, magkakaroon siya ng retroactive effect na as if from the beginning, the contract was valid. As if from the beginning, the contract was valid. Ganun yan. And with that said, take note, the moment you ratify a contract, it can never be annulled. That is absolute validity na. Hindi mo na pwedeng i-file yung action. Like, di ba dito, nag-ratify ka. Tapos, bigla ka pagdating dito, ay, ayaw ko ng contract na to, annul ko na lang. Yeah? Hindi pwede. Bawal yun. Ni-ratify mo na eh. Mutually exclusive yan silang dalawa. Either you ratify or you're annul. Or you're annul. Either you ratify that contract or you annul that contract. Pili ka lang. 3093. Ratification may be effected expressly or tacitly. Tacitly meaning implied. So, you can express ratification or implied ratification or tacit ratification. It is understood that there is a tacit ratification or implied ratification if with knowledge of the reason which renders the contract voidable and such reason having ceased, the person who has the right to invoke it should execute an act which necessarily implies an intention to waive his right. Yeah? So may dalawa tayong ratification. Express ratification, when the ratification is manifested in words and writing. Ibig sabihin, klarong-klaro. Sinabi mo, okay, I ratify that contract. Basically, ganun. Sa implied or tacit ratification, hindi express, obviously. But it may take diverse form, like for example, such as by silence or acquiescence, by act showing adoption or approval of the contract, or by acceptance and retention of the benefits flowing therefrom. Diba? For example, dito nalaman mo na, dito nalaman mo na may defect sa consent, whether that's legal incapacity or vitiation of vices of consent, yung VIMFO. Nalaman mo dito, discovery, like for example, discovery of fraud. Nalaman mo dito at this part. Ngayon, nalaman mo na may fraud. Hinayaan mo lang. Kinontinue mo lang yung contract. Wala kang ginawa. That is implied ratification. Kasi na-discover mo na yung fraud. Yeah? Tapos, alam nyo both parties na na-discover mo na pero goods lang sa'yo kasi for you, nabe-benefit ka sa contract eh. So yun, tinuloy-tuloy mo na. Di ba? That is silence on your part upon discovery. Wala kang ginawa. But of course, you still have the 4 years. Di ba? You still have the 4 years. Pero mahirap na yun patunayan eh. Pag ano yan sila dalawa, pag nag-disagreement sila sa korte na yan. Pero basically, ganun yung nangyari. Silence. Nalaman mo na. Pero kinontinue pa rin. Yeah? Walang problema. Lalo na pag 4 years na yan. Lumampas ka ng 4 years, nag-prescribe na yung time mo prescribe na yung period mo to ratify, to annul that, diba? That contract. So yung mga style yan, ganyan. O yung acceptance and retention of benefits flowing therefrom, maraming examples, diba? Marami na examples yan. So madali lang yan. Yung ratification. Basically, ang importante lang dyan is na papakita nyo na upon the discovery or upon gaining the legal capacity, upon the discovery or upon the ceasing of the vices of consent or pag legal incapacity upon being capacitated, kinontinue lang. Kinontinue, walang problema. Ang mahalaga dyan, na-ratify. Sinasabi naman yan ang problem eh. Wala yung problema. Dito, may mga examples tayo. But first, may requisites tayo for ratification. Una, pero ito, requisites for implied ratification. Una, there must be knowledge of the reason which renders the contract voidable. Ito, yung punto dito. Ito, nagiging black na talaga siya. Nalaman mo. Then, such reason must subsist. Natapos na. Like for example, yung vice of consent, intimidation, undue influence, and force. Diba? Pag nag-stop na yung acting of that, ceasing of the intimidation, force, undue influence, dun mag-start na. Then, third is the injured parties must have executed an act which necessarily implies an intention to waive his right. Yun na. Yan man yung ratification eh, pagdating sa implied or wini-waive mo yung right mo. Wini-waive mo yung right mo. Anong right, sir? To file an annulment. Kasi for you, basically, yung gaya na sabi din kanina, nagkaroon ng subsequent agreement, subsequent providing of consent on your part. Ito, may example tayo, di ba? S, a minor sold his land to B. Upon reaching the age of majority, si S, yung minor, ngayon, ngayon, capacitated na siya, with full knowledge of his rights in the premises, instead of repudiating the contract, instead of annulling it, dispose of the greater part of the proceeds or collected the unpaid balance of the purchaser of the purchase price from B. So, this is an implied ratification, tacit ratification, because there's acceptance and retention of the benefits flowing therefrom. So, madali lang yan. So, take note of that, Ngayon, the requisites for express ratification are the same as those for implied ratification, except that the former is effected expressly in writing or in words. So, napapahabang discussion natin, pero madali lang naman tong intindihin, di ba? Baka yung iba sa inyo, hindi na ito babasahin. Hindi na babasahin. Hindi na papanoorin tong video kasi okay lang. Ang importante lang naman for us is for you to learn. If you want to watch this lecture video, okay, goods. If you don't want, walang problema. Ang importante lang naman para sa akin, may matutunan kayo na intindihan nyo yung topic. So let's go to 1394. Ratification may be effected by the guardian of the incapacitated person. So 'di ba? Nasabi natin one of the kinds of voidable contracts is based on the legal incapacity of one of the parties, 'di ba? Now, sabi ni Article 1394, ratification may be effected by the guardian of the incapacitated person. So yung legal incapacity ng tao like minor, mentally disabled, deaf mute, yeah, it can be ratified. By whom? By their guardian. Yeah? Who may ratify a contract entered into by an incapacitated person may be ratified by the guardian or the injured party himself, yung minor or yung mentally disabled, provided he is already capacitated. Yung minor, naging emancipated na, naging part na ng majority. And yung mentally disabled, naging mentally abled na, yeah? As legal representatives of their wards, guardians have the power to contract on their behalf. Hence, they may also ratify contracts entered into by their wards. So yun yung reasoning. They're the legal representative ng kanilang wards. Yung minor na yan and yung mentally disabled, deaf mute na yan. So, the fact or the mere fact that these guardians have the right or have the capacity to enter into contracts in representation of their ward, obviously, they also have the right to ratify, yeah, the contracts entered into by their ward, because that's part of their duty, yeah. So, in case the contract is voidable on the ground of mistake, ratification can be made where the parties whose consent is vitiated. Saan tayo? So, 1395, ratification does not require the conformity of one of the contracting party who has no right to bring the action for annulment. Ito na. Take note of this. Ratification is a unilateral act which a party waives the defect of his consent. The consent of the guilty party is not required. Otherwise, he can conveniently disregard his contract by the simple expedient of refusing to give his conformity. So, simple lang yan si 1395. Ang nagbibigay lang ng ratification is yung party na kung saan yung consent niya may defect. Meaning, si innocent party. Yun lang yung pwedeng mag-ratify ng contract. Kasi yung kanyang consent was defective, either through his legal incapacity or because it was vitiated through VIMFU. VIMFU? Violence, intimidation, mistake, force, or undue influence. Yung party na kung saan hindi affected yung kanyang consent, whether that's the guilty party or not, basta hindi naapektuhan yung kanyang consent, wala siyang ira-ratify. Di ba? Nonsense yun kasi yung may defect, wala sa kanya, nasa other party, either by legal incapacity or vitiated yung consent through VIMFU. Yeah, common sense. So yan ratification does not require the conformity of the contracting party who has no right to bring the action for annulment. With that said, as we have said, the action for annulment can only be brought by the party whose consent was defective. Oo. Yung may legal incapacity and yung may vitiated yung consent through VIMFU. So tandaan nyo yan. Kung sino may karapatang mag-file ng annulment, yan yung karapatang mag-file ng ratification. Kasi as we have said, di ba dito, mutually exclusive yung annulment and ratification. Yung party, yung innocent party basically, kung saan na-defect yung consent niya, siya yung may right either to file the annulment or to ratify the contract. Sir, may mga instances ba na both parties pwedeng inosente sila? Oo. 'Di ba? Napag-usapan natin yung sa last time, 'di ba, yung sa mistake, 'di ba? Kasi pag titingnan mo sa VIMFU, pag titingnan mo sa VIMFU, yung violence, 'di ba, may guilty party tayo diyan. Yung intimidation, 'di ba, may guilty party rin tayo diyan. Si force, may guilty party rin yan kasi yung nag-exert ng force, 'di ba? undue influence, may guilty party rin tayo dyan. Pero sa mistake, pagdating sa mistake, sadyang may pagkakamali lang, nagkaroon ng misrepresentation of facts or misrepresentation of law. So may instances talaga na both parties are innocent. Nagkaroon lang talaga ng misrepresentation. So in that case, both of them, ma-ratify nila yan. Or, in that case, pwede nilang i-annul yan on their own. Kasi sa violence, yung nag-exert ng violence over the innocent party, guilty siya. Bad faith yun eh. Yung intimidation, same. Force, obviously. Force. Fraud. But force sinabi ko? Fraud. Fraud. And yung undue influence. Merong nangaano dyan sa innocent party. Pero pagdating sa mistake, may instances na both of them, innocente, walang problema. Misrepresentation of fact or misrepresentation of law lang yan. So they can ratify, they can annul. Both parties, allowable yan. Kasi innocent party sila eh. Good faith yan eh. So 1396 tayo. Ratification cleanses the contract from all of its defect from the moment it was constituted. From the moment it was constituted. Yan sasabi natin, may retroactive effect yan. Dito na discover basically, tapos dito na ratify na, okay, retroactive effect. As if from the very beginning, the contract was beautiful. The contract was cleansed. The contract was valid. Perfectly valid. Yun. 1397. 1397 provides that the action for annulment of the contract, contracts may be instituted by all who are thereby obliged principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those with whom they contracted. Nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistake, base their action upon this law. Ito na. Party entitled to bring an action for annulment. Sabi natin dito, basically yung innocent party, yung walang kasalanan, basically, yun yung may karapatang mag-file. Because, ano yung basis niyan? Ang sabi ng natin, those who comes to court must come with clean hands. Yun Those who comes to court. Ito, sabi ko naman to last time, di ba? Those who come to court must come with clean hands. So, hindi ka pwedeng pumunta sa korte and to ask for the remedy and to ask for the help of the court kung ikaw yung may kasalanan, obviously. Gabi naman yun. Ikaw na yung kasalanan, ikaw pa yung hingi ng tulong, kapal ang mukha mo. So, yung pwede lang maghingi ng tulong ng korte is yung may inosente, yung walang kasalanan. So, dito, sinasabi natin, the person who can file the ratification, the person who can, ratification dito sa annulment, two different requisites are required to confer the necessary capacity to bring an action for annulment of a contract. The plaintiff yung nagpa-file ng civil case excuse me. Yung nagpa-file ng civil suit sa korte. Kasi dalawa yan pag civil suit yan, ang party na nagpa-file ng action, ng remedy, ng petition, plaintiff ang tawag. Pag yung pina-file niya against, yun yung defendant. Yun yung tawag doon. Pagdating sa tawag dito? Ano yun? Pagdating sa, nakalimutan. Pero pagdating sa Pagdating ng panahon. Tawag dito? Mental block tayo. Tawag dito. Pagdating sa civil suits yun, civil cases, yun, plaintiff, defendant, kung sino yung naagrabyado, siya yung mag-file ng kaso sa ng civil suit sa korte. Pagdating sa mga criminal cases, take note, yung naagrabyado, yung innocent party, basically, nagiging complainant na lang siya. Kasi yung mag-prosecute doon sa accused criminal, yung government na. Pero pagdating niya sa law school, pero plaintiff, defendant, plaintiff yung naagrabyado, nag-file ng petition sa korte, nag-file ng action. Defendant, yung kung sino yung ina-accuse yung nang agrabyado. Yun. So, saan natin napupunta tayo sa ibang topics? Yan. The plaintiff must have an interest in the contract and dito pala tayo. Two requisites are required to confer the necessary capacity to bring an action for annulment of a contract. So, ito yung mga requisites para valid yung pag-file mo ng annulment. Una, dapat yung the plaintiff, yung nag-file ng action, plaintiff tawag sa kanya, must have an interest in the contract. So, dapat may interest sa contract. Either, basahin natin number 2. And yung second requisite is the victim and not the party responsible for the defect is the person who must assert the same. So, yan sasabi natin. Ngayon, take note sa number 1 requirement o sa number 1 requisite, interested parties lang yung pwedeng mag-file ng action for annulment. So, sir, yung mga third persons ba? Pwede. Depende. Kung stranger sila sa contract, wala silang involvement dyan, hindi siya pwedeng umepal. Pero kapag may interest sila dyan sa contract, as provided dito sa mga examples, di ba? Pag may interest sila sa contract, yes, they can file. Oo. They can file. Basta may interest sila. May part sila dyan. Pwede sila mag-file. Pero pag stranger talaga, full stranger, wala talagang labot dyan sa contract, okay, hindi yan pwede. Hindi sila pwedeng umepal. Ngayon ito mas second the victim and not the party responsible for the defect is the person who must assert the same. Yan. Yung guilty party, hindi siya pwede mag-file ng annulment. Oo. Kahit yung successor of interest niya, hindi pwede. Hindi siya mag-file. Because, ang sabi natin kanina, those who comes to court must come with clean hands. So, yung mga innocent party lang, yung mga victim lang, yung pwede pumunta sa korte to ask for the help of the court kasi ang kapal naman ng mukha ng mga guilty party na sila na ngayon may kasalanan, sila pa yung maghihingi ng tulong sa korte. Aba, Diyos ko. Hindi naman pwede yun, di ba? So, yan So, yan. 1397 talks about the annulment. Kung sino yung pwedeng mag-file ng annulment. Interested party and yung victim innocent party. So, 1398. An obligation. Having been annulled, the contracting party shall restore to each other the things which have been the subject matter of the contract with their fruits and the price with its interest except in cases provided by law. In obligation to render service, the value thereof shall be the basis for damages. It is the same way with rescission, di ba? Kapag magpa-file ka ng rescission, make sure na may i-return mo yung na-receive mo. O kasi it is a reciprocal obligation eh. Ibalik mo yung na-receive mo, ibabalik niya yung na-receive niya from you. Di ba? Same sa rescission. Ito yung similarities, ito yung similarity ng rescission sa annulment kasi na pinag-usapan natin kanina, 'di ba, yung difference sila. So ito ngayon, yung similarity sila. Pag i-file mo yan, ibabalik mo, restitution tawag diyan. Isa sa uli mo yung na-receive mo, isa sa uli ng kabilang party yung na-receive niya from you. Ngayon, together with the fruits of the subject and the legal interest, yung ganon. So, pag personal obligations yan, where the service had already been rendered, kasi nga personal obligation yan, pag service yan, where the service has already been rendered, the value thereof with the corresponding interest is the basis of damages recoverable from the party benefited by the service. Kasi obviously, it is a service, an action, a motion on your part. Ang hirap naman yan, i-restitute, di ba? Ano yung reverse camera ka. Hindi, mahirap yung gawin. So, pera na lang, basically, yung value. So, 1399. When the defect of the contract consists of the incapacity of one of the parties, legal incapacity. The incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received from him. So, for example, out of the 100,000 pesos na na-receive, yung 60,000, paano ba ito explain? Move natin to. Si guardian, minor, Saan dito yun? Minor na lang. Minor, ay. Minor, ay. May ba? Minor. Pangit naman writing. Si minor, nagbenta ng lupa kay A. Benta sa lupa, even though minor siya. So with that said, legal incapacity to, later on, pwede niyang i-annul. Tapos ang binayad ni A sa kanya was, was 1 million peso. Now, however, the problem is, si G kinuha yung, di ba, guardian siya eh. Guardian siya. Si G kinuha yung 600,000 dyan. So, yung nagamit lang ni minor for his expenses, for his benefit, is around 400,000. Is around 400,000. So, ngayon, later on, pwede yung i-annul ni minor, pag legally capacitated na siya, yung contract, pwede niyang i-annul yan. So, magkakaroon ng restitution. Ibabalik ni A yung land, but take note, ang ibabalik lang ni minor kay A is 400,000. 400,000 lang. Bakit? Kasi ang sabi ni 3099, kung magkano lang yung na-benefit ni minor, yun lang yung isasauli niya. Kung magkano lang na-benefit ng person na previously legally incapacitated, yun lang yung isasauli niya. So, isasauli niya lang yung 100,000 pesos. So, si A, habulin yung 600,000 na nanggaling kay G. Hindi required si minor na isauli yan. Kasi na kay G yung kasi 400 lang yung nakuha niya eh. So, yung 600,000 na punta kay G, yun yung habulin ni A. Si G ang habulin ni A. Okay? Kasi, sabi ni 3099, kung magkakaroon ng restitution, kung magkakaroon ng mutual restitution, kung magkano lang ang na-receive ni minor, kung magkano lang na-benefit niya, yun lang yung kailangan niyang isauli. Okay? So, 1400 tayo. Whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault. Ito na, may loss na. Whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss with interest from the same date. So, dalawang pinag-usapan nito. So, if the thing to be returned is lost without the fault of the person obliged to make restitution, the defendant, there is no more obligation to return such things. By such case, the others na to. Let's say, for example, itong si minor ulit. Nagbenta ng kanyang Rolex. Diba? Rolex, binenta niya. Kay A. Si A, let's say, binayaran ng 50K. Rolex eh. So, in that case, si minor, let's say, sentimental value yung Rolex sa kanya. So, upon reaching the age of the majority, naging emancipated na siya, okay, nag-file ng action for annulment. Kaso itong si A, without his fault, nawala yung Rolex. Baka ninakaw or binahaan, diba? Nasunog yung bahay, basta na-loss yung Rolex. So, in that case, ano mangyayari? Walang mangyayari. Bakit? Kasi hindi pwede mag-file ng annulment. Hindi magiging valid yung annulment na ipa-file ni minor kasi yung Rolex na na-receive na hindi niya na pwedeng masauli kasi na-loss siya without, take note, walang fault on his part kay A. Nawala yung Rolex without his fault. Tandaan yan. Without his fault. So in that case, wala nang pwedeng mangyari. Okay, so hindi na pwedeng valid yung annulment. On the other hand, ito yung unang example natin, walang kasalanan, walang fault on the part of A. Pero, dito tayo sa next example natin, paano if may kasalanan ni A? Because of his fault, nawala yung Rolex, nawala yung object. Ano mangyayari? His obligation is not extinguished but is converted into an indemnity for damages consisting of the value of the thing at the time of the loss with interest from the same date and the fruits received from the thing that was given to him to the time of his loss. So, ito na yung problema dito. Kapag kasalanan ni A, bakit nawala yung Rolex? indemnity for damages. Babayaran niya yung value niyan together with its fruits, legal interest from the time it was lost. So yan na, pag walang kasalanan, okay, recap tayo. 1400, sabi. Pag nawala yung object, ito yung Rolex, di ba? Doon sa party na kung saan inoblige to make restitution, the defendant, dito si A, yun na, tandaan niyo yan. Si A ang pinag-usapan dito. Si A yung target ng 1400, yung defendant, yung nakipagkontrata sa legally incapacitated, yeah? Yung sa hindi makabigay ng proper consent, yung defendant yung tinatarget dito. Kapag nawala niya, without his fault, okay, walang mangyayari. Hindi valid yung magiging action for annulment na ipa-file ni minor kasi walang maibibigay, walang ma-restitute si A pabalik sa kanya kasi nawala yung Rolex without A's fault. On the other hand, kapag yung Rolex nawala through his fault, yun, valid yung mapa-file na annulment. Susulong yung ipa-file na annulment ni minor. Bakit? Kasi kahit na hindi masauli yung Rolex, magkakaroon ng indemnification for damages, babayaran na lang ni A yung value together with the fruits and the legal interest. So yun, di ba? Pagdating, punta tayo sa 1401, dito naman, iba naman yung tinitingnan. Basahin natin. The action for annulment of contract shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has the right to institute the proceeding. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action unless said loss took place to the fraud or fault of the plaintiff. So, paano to? So, dito naman sa Article 1401, may separate rules siya. Bakit? Kasi dito sa 1400, yung point of view natin is from the defendant. This party. Yung consent na hindi defective. Da? On the other hand, si 1401, dito nakafocus kay people or kay person or kay party na kung saan yung consent niya was defective. Yeah? Was defective. So, saan yun? So, same gist. Sabi natin si A, pero this time, si A na yung nagbenta ng kotse, car, vroom vroom. Tapos si minor nagbayad ng 200k, let's say. So, ang sabi dito, dapat sinusulat itong mga rules na to. Kasi, may iba-ibang rules nila eh. Iba-ibang rules depende sa point of view. Diba? Naihi na ako, pero tapusin ko tong articles na to. So, saan yun dito? Yung sasabi ko kanina, ito. Yeah. Nag-enter si minor. So, minor yan siya dito. Ito naman si A. Sa yung defendant, basically, binenta niya yung car niya kay minor. Si minor nagbayad ng 200k. Na ano siya sabi ni 1401 dito? Ngayon si minor, legally capacitated na siya. So he can file an action na. He can sue na. So he file an action for annulment. Now take note of this. So sabi niyo, the action for annulment of a contract shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has the right to institute the proceedings. Ngayon, who has the right to institute the proceedings? Si minor. Pag naging legally capacitated na siya. Yeah? Kasi ang point of view ni 1401, kung sino yung may defective consent, kung sino yung victim, yung innocent party, perspective yan dito. Yung sa 1400, perspective ng defendant. Okay? So with that said, anong mangyayari? Ngayon, in this case, di ba yung possession of car na kay minor? Ngayon, if the car is lost, ano mangyayari sa action for annulment niya? If the car is lost through his fault, di ba? Through his fault, ito lang siya sabi ni 1401 eh. If the car has been lost through his fault, yung action for annulment niya, extinguish. Bakit? Hindi niya naman sasauli. Kawawa naman si A. Alang, ibabalik niya yung 200,000 tapos wala siyang marireceive. Di ba? Ganun yan. Pag kasalanan ni M, nawala ang kotse. Ganun. Ngayon, pag hindi niya kasalanan, ano mangyayari? Klaro naman sabi ng batas hindi lang, ma-extinguish lang yung action for annulment niya kapag kasalanan niya through his fault na wala yung kotse. Either through either through fraud or fault of the person who has the right to institute. Ngayon sir, pag walang kasalanan, anong mangyayari? Then ghost lang. G lang. Walang problema. Continue pa rin yung action for annulment. Kasi klaro naman ang sinabi ng batas Yeah, klaro sinabi. If it is lost through the fraud or fault of the person. Yeah? Fraud or through the fault of the person. Hindi pwede ma-extinguish yung action for annulment na final niya. Pero kapag hindi naman niya kasalanan, okay, proceed yan. Sir, napapano yan? Anong isasauli niya? Yung value ng kotse. Yung value ng kotse. Yun yung isasauli niya together with the legal interest. Yeah? Ganyan yung mangyayari. So, ganyan si 1401. Pagkasalanan, ito, ganyan si 1401. So, balikan natin si 1400 para differentiate. 1400, perspective ng defendant. Defendant. Ito yung nag-institute ng proceedings kasi yan yung right niya for the action for annulment. So, ito yung defendant. So, in that case, yung possession ng Rolex na sa kanya. Kapag nawala, ito, through his fault. So, this has been lost through his fault. So, kapag yung Rolex, na possession niya nawala through his fault, yun, kailangan niya mag-restitute pa rin siya, continue pa rin yung annulment, pero ang ibibigay niya yung value ng Rolex na lang, together with the legal interest, fruits, yun. Pagdating dito sa 1401, perspective na ng minor, ng nag-file ng action for annulment, So, kapag nawala niya yung kotse, through his fault, hindi niya po, yung action for annulment niya, extinguish, labot. Pero kapag nawala, hindi niya kasalanan, continue lang yung action for annulment, ang gagawin niya na lang yan, ang ibibigay niya na lang yan kay A, ang isasauli niya na lang kay A, yung value ng kotse together with its fruits and legal interest. So, yan. Sa 1402, as long as one of the contracting parties does not, ito na, parang may conflict, di ba? Pag babasahin si 1402. As long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. So sir, paano yan? Parang conflict silang dalaw. Parang nag-conflict si 1402 kay 1400 pati kay 1401. Walang conflict dyan. I-harmonize mo yan sila. You will try to make sense. Isa yun sa mga statutory constructions ng law natin na if there's a perceived differences between the provisions of the law, ang una mong gawin is to try to harmonize them and try to make sense out of it. Which is applicable in this part as you can see or as you can read sa example. Diba? Kasi kung titingnan mo si 1400, ano yan? Diba? Kung titingnan mo si 1400 or basta yung gist mo na ni 1402 is kapag hindi na daw masasauli yung, di ba? Kung hindi na daw masasauli kasi nawala daw yung Rolex or nawala yung kotse, wala na daw restitution. So, wala na daw annulment. Which is true. Yeah. But, 1400 and 1401 has provided some instances na pwede pa rin magkaroon ng annulment. Pwede pa rin magkaroon ng restitution. Ang gagawin na lang is to indemnify. Ibibigay na lang yung value. Yeah? Value ng Rolex, value ng car. Yeah? Ganun yun. Na-harmonize sila. Yes, it is true. Sabi ni 1402 na kapag hindi na masauli, edi wala ng restitution. Kasi kawawa naman. Paano magko-comply? Kawawa naman na yung isa magbibigay. Isa sa uli niya, yung isa walang may isa sa uli. Which is true. Pero 1400 and 1401 has provided some instances na kung saan, pwede pa rin magkaroon ng restitution kahit na nawala na. Oo. Diba? Dito sa 1400, ulitin lang natin para mas maklaro. Dito sa 1400, ulitin natin. Anong sabi? Diba? Si M, nagbenta ng Rolex, naka-receive ng 50K. 1400, perspective ni defendant. Yung Rolex nawala through the kasalanan of the defendant. Pwede pa rin restitution? Pwede pa rin. Kasi kasalanan niya, bakit nawala eh? So, ang gagawin na lang, isasauli niya na lang yung equal value ng Rolex at the time it was lost, together with the fruits and legal interest. Di ba? Pero pag hindi niya kasalanan, bakit nawala yung Rolex? Yeah? Hindi kasalanan ni A. O yun, 1402 mag-apply. Huwag mong pasurusahan. Hindi naman niya kasalanan eh. Di ba? Hindi naman kasalanan. Bakit nawala? Huwag mong parusahan yan. Ngayon, dito naman kay 1401, yeah? Anong sabi ni 1401? Dito naman yung perspective ni people na may right to file the action for annulment. Di ba? Yun yung sinasabi dito. Perspective niya na. Ngayon, anong sabi? Anong sabi? Di ba? Dito, naka-receive siya ng kotse. Oo, yan, na-receive niyang kotse. Kapag nawala yung kotse through his fault, di ba? Or fraud committed by him, by M, then, hindi na siya pwede mag-file ng action for annulment kasi kasalanan niya eh. Bakit nawala? Pero kapag yung car nawala, not through his fault, not through the fraud he committed, wala siyang kasalanan basically. Good faith siya. Then he can still file an action for annulment. It will still proceed. So sir, anong isasauli niya? As we have said kanina, equal value na lang ng car na nawala at the moment it was lost, together with the legal fruits, together with the fruits and legal interest. So yun, as you can see, anong na-observe nyo? Kapag kasalanan nila, nga, dito kapag kasalanan niya, kailangan niya pa rin mag-indemnify, equal value. Pero pag wala siyang kasalanan, si A, wala siyang sasauli. O yun, applied si 1402 dun. Yeah? Dito naman, si minor, perspective, nang nag-file ng action for annulment. Kapag nawala niya yung kotse, kasalanan niya, hindi na siya pwede hindi na pwede mag-file ng action for extinguish yung action for annulment niya. Applicable si 1402. Pero pag wala siyang kasalanan, bakit nawala? Okay, pwede pa rin siya mag-file ng action for annulment. Ibibigay niya lang yung yung equal value ng kotse together with the fruits and legal interest. So yun, na-harmonize mo si 1400, si 1401 at si 1402. Ganon yun ang style. So with that said, tapos na tayo sa voidable contracts. Okay?